for the defense in the Eric Campbell trial. I'm joined by Ken Belkin. Ken, 2 defense attorneys made closing arguments. Is that usual?
I'm a little taken aback. I mean, look, it's not uncommon to have more than one defense attorney on a team, as we've seen in a lot of cases, but they usually, the work is, it's delegated, and closing argument is typically delegated to one attorney. And it's very strange that they felt the need to have someone bat cleanup. I wonder if this was planned out in advance, or if, the second attorney looked at the first attorney's performance and thought to himself, maybe this guy needs to up his caffeine intake, because he's really not selling this argument to the jury.
The first guy, yeah, I couldn't agree more.
Did not feel it.
It didn't seem like he cared.
Yeah.
And if he doesn't care, why should the jury care?
Exactly. And look, if you can't make yourself care, or at least fake it well enough, you shouldn't be in this business. I'm of the belief that you should care, and I always care, or I don't take a case on.
Yeah, exactly. And so, also, he was speeding through it. It was like one sentence for each point, rather than really trying to capture the whole emotional component of their defense. The abusive childhood, it's almost like he said something to the effect of, well, it's clear that he was abused, you can't deny that, and then moved on to the next point.
Yeah,
when they spent most of the trial trying to pose that as their defense.
Yeah, total string of conclusory statements. Look, he was overwhelmed. Look, he was abused. Put these jurors in that person's position. Make them feel it. I don't know if these were privately retained attorneys. I get the impression that they might have been public defenders. Usually, I'm the most liberal guy on the planet. I'm always on the side of public defenders. They should get more funding. They're underfunded, underpaid. But sometimes there's a reason people hire private defense attorneys, because when your paycheck is determined by your performance, and you're not just punching a clock, and you're living and breathing your cases, you get a different type of representation.
Right, exactly. And so the second defense attorney who came on to do another closing argument, what do you make of that? Was that an effective move? We just talked about the fact that this is not typical. We rarely see this. So why would they do that?
I mean, look, effective or not, I don't think it could have gotten any worse. I hate to poo-poo that first attorney, but he did not have feeling. You've got to have heart if you're in this game. This business demands it.
Yeah. And so does that confuse the jury, do you think, in any way, shape, or form? When you have a second closing argument going over a lot of the same points, but in a totally different way?
It almost says to the jury, look, I know you may not believe what he had to say, but listen to what I have to say too. And I don't think that's effective. I'm not into that. It's a bad look.
Yeah, exactly. And so then they went through the different charges, obviously, and they were bringing up lying in wait, murder by torture, felony murder by burglary, intentionally killing somebody with malice, the second-degree murder charge, obviously. But I noticed that the prevailing theme throughout all of these is that if he was just along for the ride, that's not enough under any of these to find him guilty. So do you think that's persuasive, and that he might get off if there's reasonable doubt about what he actually did and didn't do? Because we don't really know.
I think it's very hard to argue that he was just along for the ride and didn't know what was going to happen. This is the culmination of a multi-state crime spree with his father. He had to bail him out like 4 states ago. Come on, this isn't like the family packed up and took a trip to Disney World together. This is a family vacation out of the Twilight Zone.
Right, but Ken, I mean, to your point, a lot of assumptions have to be made, even though it's common sense-wise, it's obvious that he probably participated in some way. Doesn't there need to be solid proof over what he actually did? You have to prove beyond a reasonable doubt that he actually either took part in this, took part in the killings, formed the intent to commit the killings or the underlying burglary.
Look, and that's
is
where
there proof for that?
That's where we have to parse it a little bit and get into the specifics. And I do think, they're going to have a hard time proving intent, that he intended to kill these people, that he was involved in their murder in any way. It would have been a lot harder for the prosecution to prove that had the judge allowed the deceased father's statements into evidence, which is probably going to be the basis of their appeal when this inevitably gets appealed. But I do think the felony murder rule clearly applies here. There was a burglary. He took part in that burglary, and the end result.
But you think that there's enough to prove intent for the burglary, but not the murders?
Yes, I think there's enough to prove intent for the burglary. He was driving. He was traveling with his father during a multi-state crime spree. I think there's enough there to get to intent on the burglary. I think the murders are a little bit of a stretch further. But, certainly they can prove the burglary. He intended, he acted in concert with the father, and the end result of this burglary is an elderly couple murdered and in the back of their truck.
Just to help explain this to people who may not be familiar with the felony murder rule, if you participate in the underlying crime, is that enough to prove the intent, or do you need more?
Basically, the felony murder rule, it's a very old rule that dates back centuries ago, and it states that basically, look, if during the commission of a felony, someone dies, and it was something that was, foreseeable that could happen during the commission of a felony, so, because when you commit a felony, it's a dangerous act.
Right.
You commit a burglary, it's a dangerous act. Anything can happen.
But is being there enough to prove that you intended the crime to happen?
I mean, let's parse it. Was he just there, or did he drive his father there? Did he drive his father through multiple states where they were committing multiple felonies, and this is just the one they got caught on?
Right, but can you do that? Can you transfer the intent to the one burglary where the murder happened by saying, well, he committed other crimes too, so that means he intended that one?
I'm not saying he should be tried for other crimes that he's not charged with. But the fact of the matter is...
But does that support the intent for the burglary?
I think it does support the intent.
You do?
That they were involved in a multi-state crime spree, and the end result, look, he drove his father there, he drove his father after. Do you think his father acted alone in putting those bodies in the back of the truck? I don't know about that.
It's really interesting because in some states you don't even have to be present to be found guilty or liable under the felony murder rule.
Yeah, if you act
and obviously then it's harder to establish that somebody intended the burglary if they're not even there. But here, like you said, we have him there. He's holding the supplies. He's driving the getaway car with the bodies in the back of the pickup truck.
Yeah.
So that potentially could be enough to prove intent on the burglary.
Look, they can comb this kid's hair all they want. They can put a nice set of nerd glasses on him.
Nerd glasses.
But, at the end of the day...
Hey, I wear glasses. Does that make me a nerd?
You wear very fashionable glasses.
Oh, thank you.
They're not nerd glasses.
Okay. But so you're judging based on the type, the look of the glasses.
Well, look, they tried to dress him up and doll him up, which you do to your defendants.
Right.
People judge you by appearance, and everyone's judging everything about this guy, his mannerisms, etc. But at the end of the day, he got caught during a multi-state crime spree, and the end result was 2 bodies in the back of a truck that he was driving with his father.
Right.
Whether or not he committed the murders, all right, that's fair. He might not have known his father was going to commit the murders. He might not have taken part in the commission of those murders. But the fact is, he did take part in a burglary, and the end result is 2 people were murdered during that burglary. And I think that's felony murder.
And under felony murder, as long as he intended the burglary, he can be held liable for first-degree murder, basically, for the highest charge.
Yeah.
But here's a little catch. With felony murder, don't you need the principal in order to hold the accomplices liable?
Well, the principal is now deceased, so it's going to be a question for the jury. I think they're going to get him. I don't think he's going to get the death penalty.
Okay, they may get him because the jury buys into the case, but technically, legally speaking, I don't think you can do this. You can't bring felony murder when you don't have the principal.
Well, I would want you on my jury.
Oh, that's a good point.
Yeah.
I mean, so I totally undermined the defense case. I guarantee you we're not going to hear the defense bring that point up.
No, they're not.
Because it's a technical argument.
Yeah, they're done, the defense. I think the prosecution...
But it's true, right? I mean, this is it's not even a valid charge because you don't have the principal.
I mean, I think they can still proceed forward without the principal. He's
How,
gone
though?
now.
How? I'm challenging you here.
You're challenging me.
Yeah.
Oh, I like it. Okay, look, he was found with those bodies. He was found with the supplies involved in their murder. This was a burglary, multi-state crime spree. I think it's going to be very hard for a jury to acquit. They're going to want to punish him on some level.
Right, but so isn't the felony murder rule where you're holding somebody who maybe played a lesser role, liable for the highest offense, but don't you have to have
If you
somebody actually charged with the highest offense to show that it's an accomplice liability?
No, they just have to prove that a felony had been committed and that he played a part in commission of that felony, which I believe he did. He at some point removed belongings from the house in their truck, the body certainly in their truck. You know, a felony was committed. Burglary was committed. Now, 2 people died as a result of that burglary. Felony murder's in play.
Now, what about lying in wait? They said that it has to be proved beyond a reasonable doubt that he lied in wait and intentionally assaulted the victims, that he actually harmed them. If they don't find that he actually harmed them, then they can hold him liable under that charge. But how in the world would they know if he actually did anything? He says he didn't. The prosecution says he did.
Yeah,
how do we know who committed the killings? There were 4 people there.
Yeah, there's no evidence of the lying in wait. And as you said, there were 4 people there. 3 of them are now dead.
Right.
So all they've got to go on really is his testimony.
Right. So forget about everything else, I would say, and you might agree. It's really just felony murder at play here. Or do you think that the jury will buy into these other charges even though they don't really know what happened that night?
I think, look, I think legally analyzing the situation, I think felony murder is the only thing in play, really. You know, I think the jury is going to be emotional, and I think the prosecution is going to appeal to the jury's emotion. An elderly couple murdered in their own home or on the grounds of their home. You know, this is a jarring set of facts. And I think there's going to be a strong compulsion, if you're on that jury, to see justice.
Right. Now let's break down felony murder, because technically under felony murder, he can be held liable for the highest charge, which would be first-degree murder. However, the way it usually goes in states is if someone didn't commit the actual killings, a lot of times they're downgraded to a second-degree murder charge. Do you think that might happen here?
Yeah, I think he's going to get downgraded to second degree because there's a lot of evidence sympathetic.
But you're saying that, yes, but look at how these people were killed. Do you think the brutal nature in which they were killed and the fact that the jury may do away with the death penalty, that might still compel them to go to first degree, or do you think they'll go to second?
I think they're going to go to second degree. I think they're going to have, look, as much sympathy as they're going to have at the gruesome murder of this elderly couple, they're also going to have sympathy for him. I mean, how could you not have sympathy for him? All the evidence introduced about the abusive father, the iron fist with which he ruled this family, his mother having to escape in the middle of the night. You know, I think there's going to be a certain element of sympathy that comes into play.
Now, let me go back to intent for a second, because they talked a lot about a common purpose. The defense said, you have to believe that Eric wanted these things to happen. Explain to me the legal difference when you're talking about intent between wanting it to happen. Is that what intent is? That you want it to happen, or that you go along with it to a higher extent where you're participating, you're enabling it?
I mean, I think the defense is really splitting hairs there, and I'm not one to criticize the defense, as I am more often than not on, well, I'm always on that side. But, you know, I think, look, you intend that outcome. The outcome that occurs, that it was your intent to produce that outcome. And I think to a certain extent, he intended to commit these felonies. They intended to commit a burglary. He went with his father willingly on the family vacation straight out of the Twilight Zone.
Right.
You know, they're multi-state crime.
Or out of like an Alfred Hitchcock movie, more like. I mean, with the types of weaponry that they were using.
Yeah, bizarre. I mean, not exactly.
Crossbows is this Robin Hood?
Yeah, it's not the father. Not the father-son bonding we had in the Belkin family, but, you know, a different type of bonding, you know. But look, he went on this spree. He could have bailed out at any moment. And especially, I think the prosecution's going to hone in on the fact that he was a willful participant in this. His father was taken into custody in Texas, and not only did he not leave and try and escape this, he actively took steps to bail him out and did, in fact, bail him out.
Yeah, so it's reasonable, according to what you're saying. I would have to agree with you that he probably intended for the burglary to happen so that they could get the money that he needed, or at least felt compelled to have his father get the money that his father needed so they could continue to live. I mean, this was very much an act of desperation.
Yeah, I mean,
but not intended the killing.
The son is an adult, and he doesn't have any real psychiatric issues. I'm not saying dissociative identity disorder or PTSD aren't real psychiatric issues, but he didn't have any.
Really, it sounds exactly like what you were saying.
Well, hold on. Let
Maybe
me
you
qualify
misspoke.
it. Let me
Right.
qualify it.
Yeah.
He doesn't have any disorder that affects his ability to perceive reality. He's not
Like a schizophrenic, right.
He's not having hallucinations or delusions of grandeur. He's having some trauma, you know, but at a certain extent, I think he did have the ability to veer off this road he was on with his father.
So then that means you don't buy into this whole defense theory of that he was going through post-traumatic stress disorder related to his abusive childhood. And literally, it sent him into a fantasy reality while this was going on.
I'm not saying I don't buy it. I think it's a plausible defense. I don't think it was effectively
Presented.
Yeah, it was not effectively presented here.
And why is that? Just because what we were saying before, that the defense just didn't really even show the emotion or go into the level of detail in the closing that we would expect?
Just everything. There's a very lackluster attitude in the defense in this case. You know, these aren't, look, I don't mean to poo-poo them or criticize too harshly, but I don't see the heart. I don't see the emotion pouring out of them, the love for this kid. When you're a defense attorney, to a certain extent, you have to love your client.
Yeah.
You really do.
Yeah.
Because if you don't love them, if you don't believe in them, if you don't have the heart, how can you expect a jury to?
Right, exactly.
As you said.
Right, so then where does the prosecution go from here? Do you think, and let me ask you this as a strategic move, does the prosecution ever alter what they're going to say in closings based off of what they hear from the defense?
Yeah, I'm sure the prosecution is out in the hallway right now revising their closing.
Is that a sarcastic remark?
No, I'm sure they are. You
really?
always do. And look, unfortunately, and I hate the fact that this is the way it is, the prosecution gets to go last. I'm of the belief the defense should go last.
Why is that?
I just think it's this person's life at stake. He's the one on trial. He should get the final say. You know, whatever happened to the victims, I understand it's horrible, but this man's life is on trial. His life is at stake now. And you're at a strategic disadvantage. With, you know, there's a lot of research that suggests that people believe the argument last presented to them.
Oh, okay.
And
so
I
this
think
is like one of those statistical findings.
Yeah.
With regard to the jury.
Yeah.
Have you heard about all of those surveys that show that a lot of the jurors will rule along with the lines of who they like in popular sitcoms and miniseries? So if they love like Law and Order, what is it, SUV?
Yeah, SVU. That's a different show.
Law and Order Mini Compact Jeep. Yeah, no, but if they like the prosecution in that series or the defense, that they'll rule for the defense or the prosecution accordingly in the
Look,
trial.
Likability of the attorneys is actually a big factor, unfortunately. You know, it shouldn't be. There are attorneys, defense attorneys that I know, very prominent defense attorneys. The one that I know, he likes to wear the ugliest tie possible to the first day of jury selection and make a joke about the tie. And he looks, people think he's like a buffoon for doing this, but it's actually very intelligent. He then looks at the reactions of the jury to him making the joke about his tie, and he looks and sees who smiles and who just like makes the frumpy face. And he gets rid of those frumpy faces because he knows they don't like him for whatever reason, and they're just not going to like anything he has to say.
Right. So then the drama of it all, to your point, how important is the performance? And do you think this is something that's underestimated in the criminal defense realm, where people don't really hone their acting skills?
I think you need to hone your acting skills. It's a performance. But the best way to hone your acting skills is to really believe what you're saying and believe in your client. You know, if you really believe it, you don't have to act.
Right, but if you don't have that passion, is
you
it
gotta
possible
make
to feign
yourself have
it?
it.
Yeah, I mean, because we were talking before about prosecutors. Their job is to, you know, to prosecute a case whether they agree with it or not. I mean, like I said, sometimes they'll offer plea deals, but that doesn't mean that they personally agree with what they're doing all the time. And so they don't have that discretion of what clients to take on the way that a defense attorney does. So how do they get passionate about things?
Prosecutors typically have a crusader type mentality. The good ones. The good ones have a crusader type mentality.
Isn't that a bit blinding though sometimes?
It is blinding, and you know, sometimes you really have to like bang on the door and kick it in to try and get them to see things from your side, especially in the plea negotiation process.
Yeah.
But by the time you get to trial, I mean, you guys are very far apart from desired outcomes.
Well, now we will see how the prosecution opposes the defense's argument and lackluster performance, as we've been critiquing. So let's head to the courtroom.